Hi and welcome back. Today I'm going to talk to you about evidence in chief, which is different to cross-examination, which I'll deal with in another video, so if you want to be notified about that, make sure you subscribe and hit the bell icon. Evidence in chief is your opportunity to give evidence in court for the side for whom you wish to give evidence. So if you are a prosecution witness in a criminal trial, it will be the prosecution barrister that asks you questions for your evidence in chief. Cross-examination, on the other hand, will be the defense barristers asking you questions, effectively testing your evidence and putting your credibility and your reliability under pressure to see how reliable your evidence is. As you can imagine, there are rules about how evidence is given by witnesses in court. In order to explain this properly, I need to explain the types of questions that are permitted in evidence in chief. The most fundamental rule about evidence in chief is that the questions that I ask cannot be leading in the sense that I'm suggesting what the answer is that I'm expecting from a witness. Unless, of course, that the item that I'm asking a question about is not in dispute. For example, if it is not in dispute that a Mr. Stevens was at a particular place at a particular time, I can lead on that element of the facts because the defense may not disagree with that. It may be what he did at that place and time that the defense disagree with. In fact, the court will expect the barrister to lead on issues that are not in dispute because it will save everybody time. So for example, and in this case, I would say, Mr. Stevens, I understand that you were at this place at 12 noon. Is that correct? He would say yes. What I'm doing is establishing exactly what we're talking about so that everybody knows what my next questions will pertain to. But there's no problem in leading Mr. Stevens about where he was and when he was there because the defense don't disagree with it in this scenario. However, what he did while he was at this place at this time may very well be in dispute, so it's on that point that I absolutely cannot lead Mr. Stevens as to what his evidence should be. For example, if he saw somebody at this place at this time and the defense disagree with who it was that Mr. Stevens say he saw, my questions need to be completely open and non-leading so that Mr. Stevens' evidence will stand on its own. For example, it may not be disputed that he saw a person at this place and time. So I can still say, I understand that you saw a man whilst you were at this place and time. That is permitted so long as the defense accepts that there was a person that he saw at this place and time. The point in issue might be that Mr. Stevens was mistaken as to who it was or the description of the person that it was that he says he saw. In this scenario, I will be saving everybody time by narrowing down the focus of my questions to where he was, when he was there, and the fact that he saw a man there. My questions then need to become perfectly open and non-leading so that the evidence that Mr. Stevens gives is all of his own and not anything that I am suggesting. This is a common scenario in cases of misidentification and alibi, which is the defense of not being there and being somewhere else. My questions to Mr. Stevens must be open so that he can identify the description of the person that he saw, so that we put that forward as evidence as to who it was we say was at that particular place at that particular time. So in this case, if I were to say to Mr. Stevens, what colour coat was the man wearing? In this case, the question presupposes that the man was wearing a coat. Now, the defence may not have agreed that this man was wearing a coat at all. Therefore, my question is leading in the fact that I've suggested he's wearing a coat. The more appropriate question would be, what was the man wearing at the time? The answer would then be, well, he was wearing a coat, maybe he was wearing a shirt, wearing jeans, and a pair of boots. Then I can ask my questions about each element of the clothing, which may narrow down the focus of the identification. I can then say, what colour coat was he wearing, what colour shirt was he wearing, what colour jeans was he wearing, and what type of boots was he wearing. There is something of a basic rule that can help us to ensure that these questions are open and non-leading. This is so long as they begin with a particular word, they will very often be a non-leading question. These are who, what, where, when, why, how, describe, and explain. Each of these words will usually lead to a question that is non-leading, save for the example that I've given about the coat. If I'm asking what colour something was, I need to make sure that whatever this something was hasn't already been suggested to the witness if it's not accepted that this something was in issue in the first place. The other element of examination in chief, besides the questions, is the format that this examination takes place. Now, whilst there's no strict format that we have to adhere to, there are some formats that generally work better than others. This I like to think of as themes and issues as one category and a timeline as another category. For example, a timeline may be a series of events that unfolded, either over a matter of minutes, hours, days, or even weeks. But it may very well be that a jury in a criminal trial listening to this timeline may not fully understand what's going on in the timeline without first having some of the issues and the themes explained, such as what type of person is involved, what type of place it is, or if there's something specific, such as a handbag or a suitcase that features very prominently in the story or the timeline, then this needs to be explained so that when it pops up in the timeline, a jury will understand how this element fits into the overall timeline and be able to understand it and make a decision on it. For this reason, there are several elements that will need to be explained before the timeline so that these elements are understood before we get going in the timeline. And there are some things that might need to be explained afterwards, which are perhaps not relevant to the timeline at all. Perhaps they are things that happened afterwards, such as a police interview or other issues that will just help the jury make a decision once they have heard all of the evidence. So taking a pub fight as an example, before going through the timeline of events, it might be really useful for a jury to understand the layout of the pub, how big it was, how many people were there, what time of year this happened, all of those sorts of things, so that when we get into the timeline, the jury will already have an idea of what kind of pub it was, what kind of clientele frequent the pub, and what size it was, and all of these sorts of things, so that when we get to that element in the story, it doesn't need to be explained. This is important because if we get partway through a timeline and then jump out of the timeline to explain something in great detail, then the story and the understanding of the timeline has sort of been lost. So it's important to understand these things before we get into the timeline. Likewise, the relationships between any of the parties, maybe the person that we are questioning that was involved or witnessed this pub fight, whether they have a relationship to the defendant or complainant or anyone else in the pub, or whether they were working there, anything of this nature. For example, if it was a waiter or waitress at the pub at the time, it might be useful to know that they've got a good working knowledge of the pub and the clientele and all of these sorts of things before we get into the timeline, because that makes this witness's evidence particularly relevant when we get to the timeline, so that the jury listening to it can understand whether or not the witness is particularly familiar with the pub, the surroundings, and maybe the people involved. So that is a broad overview of examination in chief, but why don't you drop me your questions in the comments box below so that I can follow up either in the comments or in subsequent videos to explain any one of these bits that might be helpful to you. But remember, cross-examination is a completely different type of questioning, so make sure you subscribe and hit the bell icon for when I release a video of my overview for cross-examination. And as always, thanks for watching.